Hello friends, so let's have a look on rights of the bailor. There are two rights: right of termination, right to demand return of goods anytime in case of gratuitous bailment. Number one, right of termination. Even before completion of the time period or even before the completion of stated purpose, bailor can get back his goods from the bailee, but only when the bailee uses the goods against to the terms and conditions which was mentioned by the bailor. That means inconsistent use or unauthorized use. In the case of unauthorized use by the bailee, bailor can terminate the contract and he can get back his goods. The second one, right to demand return of goods any time in case of gratuitous bailment. In case of gratuitous bailment, that means bailment without reward for free of cost, bailor can get back his goods even before the stated purpose or even before the stated time. But we have to remember one thing: he has to compensate the bailee if bailee has suffered any loss due to this gratuitous bailment which was terminated premature, that means before the stipulated time. And rights of the bailee: delivery of goods to joint bailors. So joint bailors means the good was owned by two persons. A and B are the owners to this car, and the car was delivered by B to C. Now he is the bailee to whom he delivered the car once the purpose is completed, that is the delivery of goods to joint bailors. Now C can deliver this car to B or A or any one of them or as per the contract. Delivery of goods when bailor's title is defective. So when the bailor's title is defective, he should deliver the goods to the bailor when he doesn't know who is the real owner. Means A delivered his car to B, but in fact that car was owned by C. Now he may deliver the car to A once the purpose is completed, and he is not liable since he doesn't have any idea about this car is owned by C. And the next one, right of lien. Right of lien. Lien means retaining the possession of goods. Lien means retaining the possession. So what is meant by lien? Bailee's lien. There are two types of liens: particular lien and general lien. In the case of contract of bailment, bailee can exercise particular lien only. So what is meant by lien? Let's have a look on one example on particular lien. A delivered his car for repair to B, and once the car was repaired, it should be returned to the owner. The car was actually repaired, but A was not paid the charges. B is the bailee, A is the bailor. Now as long as bailor has not paid the lawful charges to the bailee, he cannot return the car. Now the bailee was exercising the right of lien. Lien means retaining the possession of goods for any lawful charges. So for any lawful charges which was incurred by the bailee, or bailee used his skill or knowledge, so that's called lien. Generally bailee exercise only particular lien, not the general lien. Then what is the general lien? General lien means the same thing. He can retain the goods in order to recover the charges. But general lien means general balance of accounts. That means any old debt was pending, he can retain the goods. But this kind of general lien is not available to all the persons. This general lien is available to only bankers, solicitors, that means advocates, factor means mercantile agent, wharfingers. So wharf means where the place the goods were kept before loading or unloading from the ship, and the in charge of the wharf is the wharfinger. Warehouse keepers. So these persons were enjoying the general lien. In the case of contract of bailment, bailee exercise only particular lien. That means he can exercise right over the goods. That means right of the possession over the goods which he was recovered the expenses from the bailer. Next one, wrongful deprivation of goods. So wrongful deprivation means A delivered his car to B for his use on rental basis, but C was depriving B not to use the goods by creating any nuisance or any loss to that car, who causes C. Now it's B's turn, that is bailee's turn. Bailee can file a suit against C, that is the third party who causes the loss to the goods, and he can recover the damages. And rights of third party. So third party means the goods which was delivered by the bailer, that goods was owned by third person, that is the real owner of the goods. A delivered car to B, but that car was really owned by C. Now what are the rights are available to C? C may approach the court, stop delivering of the goods to the bailer. He may approach the court against B, that is bailee, for stop delivering of the goods to the bailer. The second one is to decide the title to the goods. The third party, that is the real owner, may approach the court to decide the title of the goods. So these are the rights of bailer and rights of bailee. And in next class we will see the termination of bailment and finder of lost goods. See you friends.